Okay. All right. Welcome, everyone. Can everyone hear me all right?
Yes.
Okay. Good. I'm going to take that as a yes. If anybody's having any trouble, let me know. But what I wanted to talk about today was, I think, the two most significant things that have happened since the last meeting last week. One is that the registration rights order was approved. And this is a big deal for a couple of reasons. The biggest issue and the biggest concern that a lot of people had was that because of the hedge funds' involvement, there was a concern that the hedge funds that now own PG&E would be able to sell their shares in a manner or in a way that would be prejudicial or disadvantageous to the trust. And so with the registration rights agreement, which explicitly states in the order that the equity backstops, which are the hedge funds, cannot be granted any rights or any privileges that are not given to the trust, it means that something like that is not possible. So that was a concern that had been raised by a lot of people, and it was certainly a justifiable concern, but it's now not an issue. So I think that was a very positive thing. And the other thing that goes along with the registration rights agreement was what's referred to as the NENI, which is the net normalized income. That has been also agreed upon. Now, it's not final. It won't be final until next year, but right now it is just over 2 billion, and I believe it's 2,079,000,000, something right in there. And so when you do the math and you multiply that times 14.9, and then you take 22.19%, it comes up with just over 6.8 billion. So right now, that's the value of the stock that the trust is going to receive. It's just over 6.8 billion, so it's a little bit more than 6.75. I think the key in terms of holding its value and making sure that the trust has enough money to fully compensate everyone is for the value of the stock once it's issued not to go down. And so one of the concerns that a lot of people have is the fire season. Obviously, this is going to be a very active fire season. We've already seen an increase in the number of fires that have been started. But the reason why I'm not as concerned about that as I otherwise would be is the AB 1054. And that brings me to the second issue, which is the fact that yesterday the judge signed a memorandum order, which is not a final order, but it's a tentative order approving PG&E's plan. And that means that for all intents and purposes, while he certainly has to issue a final order next week, it is a done deal and PG&E can emerge from bankruptcy prior to June 30. And that means that they will have access to the AB 1054 fund. And that's that $21 billion fund that was set up by the legislature and the governor through AB 1054. And so what that means in practice is that as long as PG&E or any other utility files a maintenance and inspection plan with the CPUC, gets that plan approved by the CPUC, then as long as they are in compliance with their plan, as long as they do what they have told the CPUC they are going to do, then in the event that their equipment starts a fire, they cannot be required to pay anything over and above the amount of their insurance. Instead, once they exhaust their insurance, then the AB 1054 money will kick in, and that will be used to pay any damages that are incurred by fire victims that's not covered by insurance. And what that means practically is it essentially is a guarantor that the stock is not going to go down as a result of a fire. Now, obviously, PG&E could decide not to comply with it, and you could have another fire that they were responsible for and that AB 1054 did not apply to. But I think at least in the short term, that's very unlikely. I mean, one of the things that came out of this is that PG&E has now completely changed their board, something that has not been done in any of the prior fire litigation. Sometimes they would change CEOs, but it was always somebody who came up with the company. And so the culture of the company, which put profits over safety, never changed. Now, while I'm not going to say that PG&E is now all of a sudden going to be the best corporate citizen on the face of the earth, I think the fact that they've completely changed their board of directors and that they've brought in new management from outside, the current acting CEO is from AT&T. It's a completely different culture. We're at least optimistic that the new company is going to be run in a better fashion. And I think if for no other reason, it's in the interest of the hedge funds that now own stock to make sure that happens. The reason those hedge funds bought this stock is that they believe that over the next 2 to 3 years, it's going to go up substantially. And if you look at, for example, the last PG&E bankruptcy, that's exactly what happened. They emerged, and within, I think it was 3 years, the stock had more than doubled. So that's what they want to do. And if they're able to do that, and AB 1054 provides them with the vehicle to do it, then they are going to make incredible amounts of money. But at the same time, it means that the stock not only is going to hold its value, but in all likelihood is going to rise. So instead of there being, for example, 13.5 billion available to compensate the victims, there may be 14, there may be 14.5. That's the hope, so we'll see what happens. But I think given all that has happened, we're in as good a position now as we possibly could be. We got the registration rights agreement we wanted. We've got the NENI agreement that is at the number, it's actually slightly above the number that we needed. And finally, we have the judge approving PG&E's exit from bankruptcy. So the final piece of the puzzle is to get the money delivered on or before August 29th. Obviously, we should not be celebrating until that happens. But once that happens, then the trust can start distributing the money and we can start getting all of you compensated. So I'm happy with where we are now. I'm optimistic, but we still obviously have a long way to go. So the next steps are going to be, now that the litigation portion is basically over, the next step is going to be getting all of the information and the claims submitted to the trust. And we're still working out the details for some of the finer points, but the broad strokes we know, and they're going to be pretty much the same as all of the other cases that we've been involved in terms of fires. So I think that the types of damages and the way they're calculated are going to be the same. So that's kind of a quick synopsis. Let me go through the questions that we received, and then we'll open it up and answer any questions that you have. So let me take a look at what questions we've received. Okay, first question. Are claimants responsible for paying taxes on attorney fee portion, or do the attorney pay the taxes on whatever fee compensation they receive? That is an easy one to answer. The attorney has to pay the taxes on the attorney fee portion. The way that it works is that when a claim is finalized, they come up with a number and then the money is sent to the attorney. So we receive it. From that, we take out our fee and our costs, and then the balance is what is sent to you. And that means that you never had possession of the attorney fee portion or the cost portion, so you do not have to pay taxes on that portion. And I'm not saying you have to pay taxes on the entire amount. Again, that's not something that we can give an opinion on. Again, I really recommend that you contact a CPA or a tax attorney, and we can certainly give you a recommendation if that would be helpful. Okay, next question. In your update letter yesterday, you say payments will begin in October and take another year. Why is paying the victims always getting pushed back? What happened to August, September? Okay, so there's a couple of different dates to keep in mind here. First of all, the August 29th date, and this has been the date since the RSA, which is the Restructure and Support Agreement, was signed back in December of last year. The August 29th date is the date for the first payment by PG&E to the trust. So it's very important to distinguish those two. There is the payment by PG&E to the trust, but again, that's different than the trust making individual payments to victims. So I just want to make sure everybody understands that. The date for the payment by PG&E to the trust is still August 29th. It has always been August 29th. That has not changed. In terms of the payments to the individuals, that's going to take a little bit more time because the trust has to process the claims and then come up with what they believe the appropriate number is. They then have to get that number to the claimants and the attorneys, and then the claimants and the attorneys have to decide if they want to take it or if they want to go through mediation, arbitration, or some of the other things. That's obviously going to take some time. It may be that it can get done more quickly than we think, but right now, what the trustee told me earlier this week is that he believes it's going to be October that the first checks are going to be actually issued. That means the first payments to the individuals. Obviously, if it can be done sooner and it can be done in September, that would be great. That is a pretty quick turnaround. So hopefully it can be done then. But again, August 29th is the date for funding the trust. And then it will take, obviously, a little bit of time to get everything ironed out and get payments to the individual victims. Now, the reason I said I think it will take a year before all of the claims are paid is that, and this is just going from experience, and hopefully I'm wrong, it doesn't take this long, but I've noticed that it takes some people longer than it does others. For example, in the Butte Fire case, the first settlements occurred 10 months after the fire. That said, some people didn't submit their materials to us for 2 or sometimes 2.5 years. And so that's why their claims were not done. Now, again, we've asked everyone to submit their materials now, but just knowing how people are and knowing how traumatic this was, particularly given how recent the Camp Fire was, it was 1.5 years ago. I know there will be some people from the Camp Fire who simply do not have their materials submitted until the 2-year anniversary or maybe even later. And so I just think realistically, it's going to be at least a year or so before everyone gets paid. Again, I hope I'm wrong. I hope everyone gets their material in, but I think it's going to take a little bit more time. Now, that said, remember, if you get your material in, your claim is processed and finalized, you're going to get paid. It's not like those people who get everything in at the beginning and get processed need to wait for those that are taking longer. When I said it's going to take that much time for everyone to get paid, that's what I meant, to complete all of the payments of the trust. That just is going to take quite a bit of time. But again, that doesn't mean that you as an individual can't get your materials in earlier and can't get paid earlier. Okay, next question. Will your office be contacting clients soon to review the narratives to be submitted to the bankruptcy trustee? Any projected timeline for this? Yes, this has been happening for quite some time, and it will continue to happen over the next few months. We generally do it this way. We have a process where we go through and we get all of the reports and the personal property. Once all of those are done, so that the last piece we need is the narrative, then we complete the narrative and submit everything. That said, if you'd like to get yours done more quickly, if you want to go now, no problem. Just reach out to our office and we can do that. But again, the way we structure things is we wait until all the other parts of the claim are done, then we get the narrative done, and then we submit it. Okay, next question. I want to know what would suffice as acceptable documentation other than a receipt to claim the loss of valuable musical instruments and precious exotic woods. Would a letter from a repair shop that happened to work on an instrument or someone who knows I had these items be sufficient? Yes, they would. Remember, you can only provide what you can provide. So if you purchase something and, like most of us, you kept the receipt in your home and your home was destroyed, then obviously you can't do that and no one would expect you to. Hopefully you have some pictures, whether they're on your phone, whether they're on social media, or on someone else's social media accounts. And this is something, again, I just can't stress enough. It is amazing, particularly among younger people, how frequently they take pictures that have valuable things in the background. So if you have children, if you have friends that use their phone a lot, grandchildren, anybody who takes a lot of pictures with their phone, I really encourage you to ask them to check and see if there's anything in the background of those pictures that can be used. But if you don't have any pictures, but you have, for example, a friend who can verify this, then yes, we can get a declaration from them. If you have a repair shop that worked on them, we can do that. Really be as creative as possible. Just put yourself in the shoes of the trustee and say, if I were trying to fairly distribute this money, what would I want to be able to value it and to make sure that the claim was legitimate? And when you approach it that way, usually it's pretty easy to figure out some way, but feel free to call us if you have any questions. If you want suggestions, we're happy to do that. Okay, number 5. Last week you mentioned an MAI appraisal. If it is decided not to rebuild, but to sell the vacant land, would the MIA appraisal be the free land? That is the land that was destroyed. Okay, so the way that the appraisal works is this. And again, we only use these for diminution in value claims. So if you lost a home, if you lost other structures, trees, that kind of thing, but you are either intending to rebuild or you would like to rebuild if you receive a sufficient amount of money, then we can request the cost of cure, the cost to repair, which generally is higher than the diminution in value. If you've already sold your property or you have made a decision that no matter what happens, you're going to sell, then we have to use the diminution in value. Then we need to get someone who has an MAI designation, which is a designation for a qualified appraiser, and they will give us the value of the land the day before versus the day after. And that's the number that we use. We would take that, we would minus any insurance paid for real property, and then that would be the value. Okay, those are the questions that were submitted to me in advance. Chewy, do we have any other questions that we should talk about before we open it up?
Yeah, I have a couple of questions that were submitted.
Okay.
Is PG&E officially out of bankruptcy tomorrow? If not, what day will this be?
So it depends on when the judge issues the final order. He issued what he referred to as a memorandum decision, and we put that up on the website, so it's available for you. If you're curious about that, just go to our webpage, which is slffirm.com. And then if you look at the PG&E section, we have a page there that has all of the pertinent documents. And there's over 8,000, so we didn't put them all on there, but we put the ones that we thought would be of most interest. So the order approving the registration rights agreement, the memorandum order that the judge signed approving the plan, those are on there. Next week, he will sign something that is a final order, and that will be the time that PG&E officially emerges from bankruptcy.
Okay, and then the other question is the CRP finalized? If not, what is left to be done?
Okay, so CRP stands for Claims Resolution Procedures. The question is it finalized? The answer is no. We are still working on it. One of the things that we're doing now is the Chief Claims Administrator sent out a sample, and a number of us are running cases through to test it and to see what the values come back at to make sure that it's consistent with prior cases and that it's where it should be. So all of us are doing that right now. We'll see what those values are. We'll see how it works. And then we'll suggest, we have a call on the 25th where we're going to suggest to the trustee and the claims administrator what additional changes should be made. But right now, they're very optimistic that they will get them finalized by July 1st, and we can start submitting right after that.
Thanks, Jerry. I have a few more submitted through the chat just now.
Okay.
It says, we're wondering when we will be provided approximate compensation values. We have provided the documentation, but don't seem to be getting the answers.
Okay. So that's it's kind of a complicated question. If by approximate values you mean the final claim submission form, that won't be done until right before we submit it. But if you have any specific items that you're curious about, for example, if you'd like to know what your tree report came back at, if you'd like to know what the structural value was, anything like that, you can let us know and we can send it to you. Those we can get to you as soon as we get them. But for the overall value, we're not going to know until we get everything put together right before we submit it.
Thanks, Jerry. And a follow-up, I believe you might have touched on it, but it says, when is that the first claims can be submitted?
So the first claims should be able to be submitted in early July. The goal for the trustee and the claims administrator was July 1. At the hearing or at the call on the 25th, hopefully we'll get a better idea as to whether or not that still is going to work. I do believe it will be sometime in July, whether it's early July, mid-July. We definitely, I believe, will be able to get them submitted then.
Thank you. And also, just some clarification. Did you say earlier that the settlement money, the funds, won't be distributed until after January?
No. They will be distributed, I believe, starting in October. That's what the trustee told us on our call earlier this week. He said his best estimate was that they would be able to process the cases that were submitted and get everything finalized in time to be able to start distributing funds to victims in October. Now, you know, he could be a little optimistic, it could be a little bit later, but it's going to be right in there. And again, obviously, this is all predicated on PG&E being able to complete the final piece of the puzzle, which is to fund on or before August 29th. But if that happens, then we're going to see distributions to the individual victims starting in October. And again, that will be on a first come, first served basis. So as soon as you get your case submitted, it will be worked up by the trust and the claims administration, and then they will respond with essentially an offer. If that works for you, you can accept it. If not, then we can talk about what your options are, going to mediation, arbitration, those kinds of things.
Okay, and follow up to that same question. It says here that the judge said in the hearing today that payments won't be made until January.
That the what now?
That the judge today said that payments won't be made until January.
My bankruptcy attorney attended the hearing today. I wasn't there. I had a conflict. But if he's talking about any payments in January, there's a second payment being made by PG&E on January 31st. That may be what he's referring to. I would need to take a look at it in more detail. But I can tell you, I spoke with the trustee, and he believes they're going to be able to start making payments in October.
Thank you. And then I also have here, would you be able to break down what is in your latest update letter, the main points to take home?
Yeah, sure. I think the main point, the most important thing was the registration rights agreement, because that puts us in a position where now we know the trust is protected, the stock in the trust is protected, and there's nothing that can be done by any clever hedge fund managers or anything like that to put the stock held by the hedge funds in a better position. They can't offer some type of benefits to those individuals and those entities that are not offered to the trust. So that, I think, is the most important thing. After that, really the most important thing and the takeaway is that if you have any documentation, whether it's making a personal property list, whether it's receipts or anything else that hasn't been submitted, please get that to us as quickly as possible, because we want to be able to get these cases submitted promptly, and we can only do that when we get the documentation.
Thanks, Jared. Also, I'm just going off of the live chat here. Do you have a suggested template or format for the narrative that you have used with success in similar fire cases?
Sure. What we generally do and what we ask our clients to do is don't worry about how you give us the information. If you want to write it in a narrative form, if you want to just put bullet points, we just need the critical information. So if you want to write something up and send it to us, that's great. We can read it and then follow up with a call. If you want to have a call with us and then we can write it down, that's fine too. But typically the way that we do it is we're trying to make it a narrative that captures the really critical points. And the most important things are what your proximity to the fire was. In other words, where were you when the fire hit your area? Were you someone who barely got out? Were you someone who had more warning and was able to get out in advance? When you left, were you trapped? Certainly in the camp case, there were a large number of people that were trapped. In some of the other cases that happened too, but it was most prominent in camp.
Over it.
Oh, just sorry, just please mute. That's what we're looking for. Number one is what your proximity to the fire was. And then number two, we're looking for how the fire affected your life. And specifically, if you lost your home, what were your circumstances after that? Were you able to find a rental home? Was it similar kind in quality? Was it in an area where you were able to go to your job, go to school, that kind of thing? Obviously, for folks that lived in Paradise, none of that was possible. But for people that lived in other areas, how was your life affected? And so that's really what we want to know, because those are the two things that the trust is going to consider. Number one, proximity to the fire, so emotional distress, and that would include the circumstances of your evacuation. Did you have an elderly parent with you? Did you have children with you? Those kinds of things. Just in other words, in how much danger were you? And then how this affected your life. What changed? What about your life was different? The most common thing that I hear from clients is, it feels like my life was essentially put on hold for 2 years or 3 years or however long it took for me to get back into my rebuilt house. And so those are the kind of things that we want to know, specifics to you, because we can certainly provide the general information. I mean, we've familiar with so many stories that we know what the general losses are, but what was specific to you? What about your case stands out? Because everybody's case is different and everybody's case is unique in its own way. And so we want to know those specific factors that are unique to your case.
Thanks, Jared. Can you please explain how attorney costs are divided? Is it the total sum divided by the number of claims, or each individual claim separate?
Now, the question was attorney costs. So there's two kinds of costs. One is the individual cost for your case. And that would be if you lost a home and we needed to hire a contractor to give us a rebuild estimate. If you had trees or landscaping loss and we had to hire an arborist. Those costs are unique to your case, so they will be taken entirely out of your case. If it's $2,000 or $3,000, it will come out of your case. In addition, though, each case has joint costs, and those vary case to case. For example, in the Tubbs case, because so much work was required to prove liability because of CAL FIRE's unfortunate report, the costs are higher. We had to hire experts, we had to do depositions, we had to take the case really all the way almost up to trial. Expert depositions were starting when that case settled. On the other side, on camp, very little was done on liability. We'd hired experts and we had one inspection, but they declared bankruptcy so early and the litigation stopped that those costs were very minimal. So what we do there is, we do this by fire, we will take all of our clients in a particular fire and we'll look at the joint costs. So let's say, for example, that the joint costs were $1 million in the Tubbs fire. What will happen is those will be apportioned on a pro rata basis. So if you received 5% of the total amount that the Tubbs fire victims that we represent obtained, then you would be responsible for paying 5% of those joint costs. and on and on and on. And certainly it's unlikely that anyone will receive 5% because we represent over 1,000 Tubbs fire victims. So a more accurate one would be, 1 or 2%, something like that. And that's how that is divided up.
Thanks, Jerry. I have a few more here. It says, which way will claims be handled? Will they be handled on a first come, first served basis?
Yes, they will be first come, first serve. In terms of how we're submitting them, we are submitting what are known as preference cases first. And preference simply refers to a particular statute, Code of Civil Procedure, Section 36A, which says that if you are 70 years of age or older and you have a significant health condition, then you are eligible for a preference in trial setting. And so the way we've always done it, because obviously those individuals are the most vulnerable, is we've put those people at the front of the line. And typically it's between 1% to 2% of the cases that we represent. We put them up front and we put those in first, but those are only going to be a very few cases. After that, it's first come, first serve. Whoever gets their cases submitted to us, in other words, gets their information to us first, is whose case goes in first. Now, just as a practical matter, because the Butte fire happened so long ago, those cases are already worked up. So as soon as they're opened up, most of those cases will be submitted. There are a couple where we have to do additional site inspections because they've incurred additional damages due to erosion or tree loss or something like that. But the majority of them are ready to go and will be submitted as soon as the portal opens up for submissions. So that's kind of in a nutshell how we do it.
Thanks, Harry. And another question here is, wife and son are on SSDI. Would we be able to get just one check made out to me so as to not?
Yes. So the question is, if you're married or if you have a co-plaintiff, how does the check get made out? And the answer is, as long as it doesn't violate any laws, which certainly asking a check to be made out to one person does not, then that's something we can do. The way that we generally do things is that we get the money in, and then we'll give each client what we refer to as a distribution worksheet. And that will contain the settlement amount, the total amount of costs, the fees, and then the net amount that will go to the client. And you have an opportunity to look at that. If you think any of the costs are wrong, you can let us know. You can challenge those. There's a whole procedure for doing that. But once you get to the point where you say, okay, this is what I agreed to, this is the amount I agreed to, then we have a section in there where you tell us how you would like to receive the money. So if you're married, but you want, for whatever reason, the money to be made out in a check to the wife or to the husband or however, then you just say, please make this check out to Mrs. Jane Smith. And then as long as both of you sign that, then that's fine. We can do it that way.
And can you provide some clarification as to the preference issue?
Mm-hmm.
Specifically, does permanent disability count as being eligible for preference?
It would depend on the nature of the disability. So the thing about preference is, other than the extreme conditions, if you have a terminal cancer or something like that, it really is a case-by-case basis. Some people have heart issues that are very, very serious, and so you would have a 70-year-old who would qualify, for example. Other people are older, but are in very good health. In my Thomas Fire case, for example, I have a woman who's 88, and I keep saying, let me make a preference motion for you, and she says, no, I'm in great health, I don't need it. So it just is up to the individual person whether they want to do it, and then also, do they have a sufficient health condition? Obviously, the older you get, the less serious it has to be. If you're 70 and your actuarial tables would indicate that you're going to live to be 86, it would have to be, something significant. On the other hand, if you're in your mid-90s, I once brought one for a woman who is 97, there's not a whole lot you have to show. A 97-year-old's actuarial tables are not very long. So you just say to the court, Your Honor, my client's 97 and she has some health issues, and that motion is going to be granted. And so it's the same thing here. So if you believe that you qualify and you would like to get in to the preference group, just let us know and we can evaluate the case.
Thanks, Jerry. I believe that is the last of the live submissions here. I'll keep on scrolling through.
Okay. Well, what questions do we have?
I have a question. Question. Okay, and thank you very much. I have two questions, actually. PG&E pleaded guilty to the deaths up in Paradise.
Right.
What will be happening to the deaths in Santa Rosa? Will there be a similar type of plea?
No. The reason that PG&E pled guilty in the Camp Fire is that the district attorney could show that their level of negligence was not just normal. It was, in other words, it wasn't the standard negligence where someone made a mistake. It rose to the level of what we refer to as deliberate indifference, meaning essentially that it was gross negligence. It was so bad that no reasonable person could have done it. And that's the standard that you have to have in order to get a conviction for involuntary manslaughter. Because if you're just negligent, then there's no criminal liability that attaches. But in Camp, they felt that it was so bad and that the level of negligence was so egregious, and frankly, that had been going on for so long. I mean, frankly, I think if PG&E had not started the deadly Butte fire, had not started any of the deadly fires in 2017, and Camp was their first situation, they probably would not have been prosecuted. But I think we all agree that PG&E richly deserved to be prosecuted by that point. I'm glad that the DA prosecuted them, and that's why they agreed to plead guilty, because they understood that whether they could win or not, it was not in their interest to go through and have the level of their misconduct exposed. So they pled guilty. This was an agreement that they made several months ago. Yesterday was just the day that they did it, or 2 days ago was the day that they did it, and now they go forward from there.
So does that have, what does that mean to the lawsuit? Anything other than, I mean?
It doesn't really have an impact on the lawsuit, simply because liability, particularly for Camp, is not an issue. We knew from the get-go Camp would be very clear liability. If there's money left over, then there will be punitive damages that are paid out to Camp Fire victims. But I'm not optimistic that there's going to be money left over after everyone is paid.
I see.
So yeah, the only real impact is that PG&E had to pay a $3.5 million fine, which is being paid.
I see. And my second question was, with regard to the letter you sent out, you said that in your opinion, you think AB 1054 gave away too much to utilities.
Right.
And I just wonder I don't quite understand what you mean there.
Sure. I understand the reason behind it, and I don't want to be critical, because obviously it's easy for me to be a Monday morning quarterback. But at the time, my concern was that I at least felt that with this fund, which I think was a great idea, I didn't believe it should be 50-50. In other words, 50% paid by ratepayers and 50% paid by the utilities. I felt that a greater portion of that should be paid by the utilities. That's obviously just my personal opinion, but that was something that I felt strongly about. That said, the legislature and the governor went in a different direction. And so once they signed it and it became law, we wanted to make sure that we used the law to protect our clients as best we could. And the good thing about the law is it really does provide very good insurance against the stock going down, because if there is a catastrophic fire, the damages will be paid out of the AB 1054 money, and PG&E will not have to incur large losses, which would obviously cause the stock to go
Okay, thank you very much.
Sure. What other questions do we have?
I see here, is there a scenario where the trust has money left over? E.g., the stock appreciates a lot?
Good question. You know, realistically, I think the answer to that question is no. It's certainly possible, you know, conceptually, but I think realistically, what will happen is if the stock goes up dramatically, so instead of having 13.5, let's say we had 15.5, I think what the trustee will do is to award punitive damages and then take any money that was not paid to compensate the victims and give the balance out to victims on a pro rata basis as punitive damages. I'm just speculating. That would be up to the trustee, but I've never heard of a situation where in a case like this, there was money left over. The trustee and the claims administrators want to get as much money as they can to the fire victims. So I don't realistically see a situation where there's any money left over.
I have a question, Jerry.
Sure.
How you doing?
Good. How about yourself?
Good, I'm okay. I know
Good.
you just moved again, so it's been about a week.
Well, I'm glad. Is that the background or is that a backdrop?
Actually, that was a picture of the backyard from the house next door that we just moved from.
Okay. Well, it's very pretty.
Thank you. At least we didn't have to move far, right?
There you go. Okay.
My question is, since we're still kind of struggling to get our paperwork together and insurance information and whatnot,
Sure.
this might be client confidentiality, but are we the minority or the majority? Are a lot of people still, are you waiting for a lot of people to send in their information? And what is the deadline? Not that, you know, we want to wait
Sure.
till the deadline, but do we have a time period?
Sure, and it's not at all any issue of confidentiality. Most of our clients have not submitted everything yet, and that's very normal. It takes some time. Right now, they're saying the deadline to submit is December 31st. They're saying that, in my opinion, because they want to encourage everyone to get their materials in so that they can get the money distributed as quickly as possible. Realistically, there's no way that date is going to stay. They will extend it. I believe they'll extend it out at least 90 days, probably more like 180 days, because they want to give everybody who filed a claim the opportunity to make a submission.
Okay. All right, that's good to know.
Sure.
Hopefully
Absolutely.
we won't be waiting till then.
Hopefully not. Nice talking to you.
Yeah, you too.
Okay. Who's next, Chewy?
I have Ms. Kingsley.
Jerry, thank you very much for the meetings. They're really informative.
Of
I
course.
wanted to follow up with your with the information on the MAI.
Uh-huh.
So my question is, you know, an MAI is doing the fee value in the before condition and the after condition.
Right.
So my first question is, the trustee going to take the before condition or the after condition number?
Well, what they're going to do is they're going to subtract the after from the before, and that will be the diminution in value. So if it's $1 million the day before and it's 100,000 the day after, then your loss is 900,000. So that's how
And
they'll
that's
do it.
just for the fee, not for the improvements. Is that
No,
correct?
no, it's for the whole thing. So they're talking
for the
about
whole thing.
yeah, they're talking about the entire property. So what they're going to do is they're going to look at the property, determine the highest and best use, and give day before versus day after. That's how
Okay.
they do it.
So then it's a bit more beneficial than to go ahead and submit everything in the before condition and just say, we'll keep the land and then sell the land later on.
Exactly. Yeah, the cost of cure is absolutely the way to go as long as you still own the property and you're open to making the improvements if you receive enough money. If, for example, you've decided that 100% you're going to sell, then obviously you have to let them know that because they'll ask that question. But as long as you're open to doing it, then you can go ahead and recover cost of cure.
Okay. All right. So thank you very much.
Sure.
I have another question, Jerry.
Sure. Go ahead.
Let me ask, I know that preference you were talking about 70 and over disabled.
Mhm.
Is there
Yeah.
any exception to that? Like if if you're under that a little bit and you're disabled, or for individuals that are really, you know, barely hanging on by a thread? Is there any
Sure.
situation that is ever looked at?
Yeah, no, I'm glad you asked that. One of the things that we look at is we call them extreme hardship cases. So unfortunately, we do have some folks that are just in very dire circumstances, homeless, near homeless, that kind of thing. And so those are people that, all things being equal, we're going to push to the front of the line simply because they're just desperately needed.
Cool.
Yeah.
Okay, good to know.
Okay.
I had a question.
Sure.
Can you hear me?
I can, yes.
Okay, I'm sorry. I'm from Indiana. I think she answered one of mine. I talked to someone else and told them I'm 65. I was in the Tubbs fire visiting California, and I ran on foot with fire very close 6 months after open heart. And he kind of poo-pooed it. And my health now is even worse, but he wouldn't move me to the front of the line. So I don't know who to contact about that. And then I'm a little concerned. I'm very glad I didn't lose a house or anything, but it was my first visit to California. I was with 7 family members for a wedding. We were at the Hilton Garden Inn, and none of the equipment worked. In fact, my brother awoke the hotel people by a phone call, and they banged on the doors to get us out. Well, our rental car keys were in. So it was chaos because the fire was surrounding the parking lot. And we were running barefoot in nightgowns, and people weren't even stopping. We had to beg for rides. We were opening people's doors. My family split up. We ended up in 2 different emergency shelters, not knowing how the other people were. The stranger did take me to ER, and I did have smoke inhalation. And they evaluated me to make sure I could eventually fly back since I had open heart.
Yeah.
And actually just listening to this has made me very anxious. I've had the PTSD from it. So no, didn't lose any property, but my sons lost their dad in a fire when he was 34, and I witnessed a couple others. And this was by far the worst thing.
Yeah.
And nobody could help us because they were evacuating Kaiser Aluminante across the street. And, you know, when we were in the strangers' cars on the highway, there were cars on fire, and we didn't know where to go. And my son was in the other stranger's car. They had to run all the way to the highway to get somebody to pick them up. So I wonder, someone like me that did not lose a home,
Yeah.
where do I stand in this?
Well, first of all, I'm sorry for what you went through, and you're absolutely entitled to recover for the emotional distress. And if we can demonstrate that what you experienced that night, whether from smoke inhalation or from anything else relating to the open heart surgery that you had, and that problem being exacerbated, then you can recover for that as well. That's something obviously we have to look into in more detail. But in terms of what you can recover, whether or not you were fleeing from your own home or a hotel or rental property, in terms of the emotional distress, it's all the same. You're certainly entitled to recover for that because that's terrifying. The difference between you and somebody else would be if they were fleeing from their home and they lost their home, then in addition to the emotional distress, they would also be able to recover what are referred to as nuisance damages. And obviously they're much more than a nuisance, but that is to compensate people for the annoyance, disturbance, inconvenience, and mental anguish they go through when they lose property. So you can definitely recover, and we're happy to work with you on developing your personal injury claim.
Okay, who should I get a hold of? Because I'm 65 now. My health is, I'm not doing well.
Sure. The partner at our firm that handles the workup for personal injuries, there's a couple people, but I think the best person to talk to is Brody McBride. And if you just call the office and ask to talk to Brody, then they can put you through to him.
Okay, thank you.
Sure thing. Okay, who is next?
I do have a live chat here. The question says, how does the cost of cure apply to people who were renters at the time of the fire? And if the house listed is as a smaller house than what was actually there?
Okay, let me make sure I understand the question. So the question is, how does the cost of cure apply to renters? Is that correct?
Correct.
Okay, it doesn't apply to renters because cost of cure is a method for evaluating real property damages. And so if you did not own the property, then obviously you can't recover for the real property damages. You can recover for your emotional distress, and you can recover for the personal property that you owned in the home that was destroyed. But in that case, it's fair market value, not cost of cure. So you look at the fair market value of all of the items that were destroyed.
She's still on her phone.
Uh-oh.
All right.
Jerry,
Yeah, go ahead.
I was going to ask, somebody said that the amount that you can claim for your personal items is like the amount that you would get for something at a yard sale. And I said, that doesn't sound right. Oh, you're muted, Jerry. Can't hear you. There you go.
How about now?
I can hear
Okay.
you now.
So it's not a yard sale, but it is fair market value, which is different than cost of replacement. So in other words, if you lost a TV, it would be the value of that TV. So if you had a 2019 LG or whatever it is, then you would go and you would say, what does it cost to replace that particular item? It wouldn't be a brand new one. So I think what they may have been referring to is if you had something that was older and didn't have a lot of fair market value, then it might be the amount that it would sell at a yard sale. Most things are going to be worth more. But that said, there are going to be certain things that don't have a lot of fair market value, used clothes, unless they're vintage, that kind of thing.
Got it. Okay. And if you had a bunch of brand new clothes that you never wore with tags on it, would that?
Oh, yeah. No. Brand new is
still the
brand new.
price that you
And
paid for it?
yeah,
Yeah.
it's whatever you had. So if you had something new, then it's the new value. If you had something that was older, generally it's going to be worth less unless it's vintage in the case of clothes or some other things, or if it's a collectible car, antiques, jewelry, all of those things appreciate, so you can get more money. The biggest thing that depreciates are electronics. I mean, unfortunately, once you buy something, it's no longer worth what you paid for it, and a year from now, it's obsolete. So those things typically you are not going to get a lot for, unfortunately.
Like those 5 old cell phones we had in the drawer.
Exactly. Yeah, those are not worth a whole lot.
All right.
Okay. All right. Who's next?
I had a car that was damaged in the fire, but I don't have the money to take it to a shop. How do I deal with that?
Okay, that's an interesting question. Are you, so when you say you don't have the money to take it to a shop, they're going to charge you to give you a repair estimate?
Yeah, basically, it's like $100, I think, but I just don't have it right now.
Okay, just please email, and what we can do is arrange to advance that to the mechanic so they can give us the repair estimate and we can submit that.
Okay, thank you.
Okay. All right. What other questions do we have?
I'm scrolling through, Jerry, the chat. I don't see any new questions here in the chat.
Okay. All right. Well, does anybody have any other questions?
No, just thank you so much for all your hard work. Appreciate your help.
Oh, well, thank you. Thank you very much. It's a lot of fun. I love doing this. I'm just sorry that it has to be under these circumstances.
Sorry, Jerry.
So,
I did have one. Sorry about that.
sure, go ahead.
Ms. Napoli did have one question. I see her hand
Okay.
here.
Go ahead.
I'm not sure if you're talking about me, but
Oh,
I'll ask
please,
my
yeah.
question.
Yeah.
Would you give an example of a person gets a settlement? Let's say it's just round numbers, it's $1 million. And then you withdraw the experts and whatever that percentage is for that fire that needs to come from.
Okay.
Then how much of that settlement would then become attorney's fees? I just try to get an actual
Okay.
live example so I have a.
Sure. So the attorney fees are 1/3. So out of the $1 million, if you use that as an example, it would be $333,000. The costs are typically, around 2%, a lot of times less. So if you use the $1 million, they're going to be around 20,000. So the client would net around $650,000 on a $1 million settlement is how it would work.
Thank you very much.
Sure thing. Do we have any other questions?
Yes, Ms. Napoli. Ms. Napoli.
That was a different question.
Another question. When the person gets the net amount, is that usually a low figure and people are supposed to go arbitrate, or it's not?
Oh, you mean when the trust comes back with what their offer is?
Yeah.
Okay. It's interesting because this is a different process than we've ever done before. Typically, we're going back and forth with defense counsel, and obviously defense counsel always starts off very low. So we always, we never accept the first offer. We go back and forth. The idea behind the trust is to try to limit the amount of, we call them appeals.
Arbitration.
Exactly,
Yeah.
mediations. And the reason for that is because the trust has to pay all of the administrative costs. And so if people go to mediation arbitration, then it reduces the overall amount of money. So what they want to do is make essentially their best offer out of the gate. Now, I think they will, but where I think there are going to be some issues is some cases are more complex than others. And so I'm sure there are going to be cases where, despite the best intentions, they miss some of the nuances. And so that's where we'll say, okay, this is great. However, did you take this into account? That kind of thing. So we can go back and forth with them and hopefully get it to the right number. I think in most cases, probably about 50%, the initial offer is going to be good for the client and they're going to want to accept it. But I wouldn't be surprised if in about 50% of the cases, we are going to have to either mediate or in some cases arbitrate.
Okay, that's helpful. And yes, I just wondered about that. So
Yeah.
Thank you very much.
Sure.
There's a few people with their hands raised. I was trying to get Miss, I think it's Napoli. I don't know if I'm saying it correctly. Jennifer Napoli. Okay, Miss Susan Thomas.
Ms. Thomas?
Can you hear me?
Yes.
Mark.
Yeah.
Hi, Jerry. It's Mark. Thank you.
Oh, hi. How you doing?
Good. Thank you for all your hard work and putting up with me.
No problem at all.
Going back to that example where you used $1 million, if the award was $900,000 in economic damages and $100,000 in non-economic damages, from what I understood, the court is going to pay the attorney's fees. So assuming that it's a 33%, a third of attorney's fees on that 900,000, that 900 would actually become 1.2. Is that correct?
That's correct. Yes.
And on the non-economic damages, that 100,000, from that 100,000, the victim would compensate you at 33,000. So their net would be 67,000.
Correct.
Okay. I just wanted to clarify.
Yeah. No, absolutely.
Thank you.
No problem. Ms. Kingsley, please go ahead.
I had a question on the mediation or the appeal process. Does it go before a 3-person board? What's the procedure and who does it?
Sure. So the way that we've done it is you have the trustee who's in charge of everything. Then you have a chief claims administrator who we're working with to set it up. Then we have a panel of about 20 different retired judges and attorneys who specialize in mediation who've handled fire cases before. And so one of them will just arbitrarily be assigned and we'll go to a mediation with them. If we can resolve it, great. If not, then it can go before a single arbitrator or a panel of 3. It's your choice. You make the selection. And, you know, there's pros and cons to either one. If that does not work and you're still not in agreement, then you can go to the trustee and it's a completely new appeal. And you can say, this is erroneous, here's why, and we list out why we think that that award was wrong.
And who pays for the fees for the arbitrators?
That's paid by the trust. So those are part of the administrative expenses. So it's not like there's any additional cost. And that's why they don't want to encourage people to do it. They want to give people their best offers right up front. They're not trying to hold any money back like a defendant would. They're saying, here's how we evaluated it. Here's why we think this is the right number. And then it's up to the individual claimant to decide whether or not they want to accept it.
Thank you.
Sure.
Yeah, I have a question.
Sure.
Yeah, so we had some costs that were business associated. Originally, we were told that there was a cap on personal property. So a lot of that equipment wasn't even listed. We just kind of stopped, you know. Do we have to file a separate suit for business?
No. If you're talking about personal property that you had at your residence that was destroyed?
Correct.
Absolutely. Yeah, no. All you need to do is list that. And then as long as you've maxed out your insurance, which it sounds like you did, then we can recover everything over and above what your insurance paid.
Yeah, we didn't have insurance, so that.
Oh,
yeah.
okay, yeah. Then absolutely, yeah.
Okay. Okay, so.
One quick question.
Oh, hang on. I think, I'm sorry, you're listed as Jennifer Napoli?
Yeah, it's my wife.
Okay.
Yeah.
Mr. Napoli, go ahead.
Yeah. Oh, sure. So do we need to contact you to add some of those additional items, or what do we need to do there?
Yes, please do. Please just get us the most exhaustive list you can. The more detail, the better.
Okay. All right. We'll be in touch. Appreciate it.
All right. Thank you.
One quick question.
Okay. And then we'll go to this gentleman here. Go ahead.
Go ahead and let her go. She can go ahead and then I'll wait.
Okay. All right. Go ahead.
I had submitted medical claims and stuff early on, but no one has gotten a hold of me saying they needed more things. Your office would let me know if you need more evidence?
Yes, but can you just give me your name, and what I'll do is check to make sure?
Sure. It's Jacqueline, Jacqueline. Last name is Orzalak. It's O. R as in Robert. S as in Sam. Z as in zebra. U-L-A-K. I live in Indiana. And
okay.
I'd be happy to submit. I just have not heard.
Okay. Well, let me check and make sure that we have everything that we need. If we don't, then we'll reach back out and let you know.
Thank you so much.
No problem. Okay, sir, go ahead.
Yes, quick, what is the expertise of the claims, the adjusters that are going to be going through our lists and all our documentation and things like that? Because we've obviously dealt with the insurance company and had our own issue with them, and are we entering that kind of a battle? What we're turning in, or that's what I'm kind of.
Yeah, and that's a good question. No, the people that we've selected to make the decisions are people that we've worked with before. So most of them are retired judges. A couple of them are attorneys who specialize in mediation, but all of them are familiar with fire damages. And it's not going to be the kind of adversarial process that unfortunately it so often is with insurance. Instead, it's going to be, we submit it, they look at it, and they say, okay, in our experience, we're familiar with this type of a case. Here's what we think the ultimate number should be. And then they'll give that to us. If that is something that works for you, great, we accept it. If not, then we explain to them why we think it's wrong and try to get them to increase it.
Okay. And the time frame on that, say my case, say our case or our claim goes through, they come up with a number, you get back to us, say we go, no. Is it is it back to the bottom of the pile to get to them, or do we go back through?
Yeah, no, it should be fairly quick because the goal is they want to get everybody paid. So the goal is to get that done within 30 days. That's what the CRP says now, the claims resolution procedures. Again, that's not final. It could be a little bit longer, but they don't want these cases to linger. So once they look at a case, they want to try to get it done. The delay would be if we said, okay, after the mediation, that's not going to work, we want to go to an arbitration, then that's going to take a little bit more time. But it shouldn't take that long because, again, they want these things to get done.
Sure. And one other question real quick. Regarding the appraisal value that we received a week or two back, our home has already been built and everything, and that value and sold. So that value that they had pre-fire to what post-fire it's not even close to what I had to come out of pocket to build that house, to rebuild it, forget what it sold for. But the value of it pre-fire, we had it on the market and it's not even close to what they had the value at. So
Okay.
how do I get that discrepancy fixed, or what's my solution to that?
Yeah, that's an interesting situation because we don't often have that. So it's kind of a combination. Why don't we do this? If you could contact the office tomorrow, and I'd like to have you talk with one of my associates, Joanna Estrada, and go through with her what your situation is. Let's see what we can do and see if we can get it figured out.
Okay, because we've done everything. We had our phone conversation already with one of your associates up here about our story and all that. So we're all the way through everything with the list. And
Then let me back up for a second. Who have you been talking with?
Not Tatiana, the other girl. She lives in Santa Rosa. Aaliyah.
Patrice?
No, Aaliyah.
Oh, Aaliyah. Okay. Yeah. All right. Okay, let me do this. Let me check with Aaliyah. What is your name?
Sean, S-E-A-N, Harris.
Okay.
Wife.
All right, let me check with Aaliyah and get some more detail about your case, and then I can get back to you, and we can see if we can figure out what the discrepancy is.
Okay.
Hey, Mr. Harris, Jerry, just it has been Brecky is listed as the temporary contact for Mr.
Okay, I'll reach out to Brecky then as well.
Brecky. Okay.
Okay.
All right. Thank you.
Sure. Who's next?
I spoke with Alex at one point in time, and he said that I'd have to have a doctor sign off on PTSD, but I don't have medical insurance right now. How do I go about that?
Well, it depends. To make a formal claim for PTSD, in other words, to say that I suffer from a diagnosis of PTSD, you would have to have a doctor sign off, but you don't just to make a non-economic damages claim. So what we generally find is unless you are in a situation where you've been diagnosed and it's so severe that you can't work or something like that, it generally makes the most sense just to list it as part of the non-economic damages claim. Now, if you're concerned about PTSD and you think that you would benefit from seeing a therapist, then that's something we can arrange for you to do. We can just do it on a lien, but that's a decision that you would make. So is your feeling that you would benefit from seeing a therapist and you'd like to see what diagnosis they would give? Or is it just that you wanted to get it done for the purpose of the suit?
I was just curious. I had tried to talk to Alex about it, and he never contacted me back. So I was just wondering.
Well, I'm sorry about that. Let me make a note and I will reach out to him and make sure that happens. This is Nicole Lorenz?
Yeah.
Okay. All right. So let me look at that, and I'll have him discuss it with you. And if you decide you want to go see a doctor, then we can do it, like I said, on a lien basis, so you wouldn't have to pay anything out of pocket.
Okay, thank you.
Sure.
I have a question.
Yeah, go ahead.
So, Jerry, I already have PTSD and anxiety disorder from 2000, and I've been on permanent disability. And because of the fire and, 5-6 moves later and all the stress in between, a lot of, anxiety attacks and leaving a few jobs that I tried to do, because I do try to work part-time. And I was let go from the last job with a letter because I was crying too much on the job. So do you need a letter like saying I've been disabled this whole time, and those letters that I got because I lost those jobs because of PTSD, keep all that?
Anything like that. I mean, anything you have would be beneficial. So the diagnosis would be good. And then anything you can get from jobs saying that it is interfering with your ability to work, that would be great.
Oh, and then also seeing my doctor in between time, and I'm having it on paper that I have it has been exacerbated, from these trials we've been going through.
Yeah. No, I'm sorry about that. And yeah, that would be helpful.
All right. Thank you.
Thank you.
And just one more. I have somebody here wanted me to mention that Heartstrings Counseling out of Loomis does free counseling sessions. It may be helpful for some.
Okay.
And
good.
Wanted me to share this with everybody.
Great. All right. What other questions do we have?
It looks like Denise or Dennis Ryan.
It's
Okay.
Denise. Thank you. Hi. Can you hear me?
Yes. How you doing?
I'm doing good. For the young lady that just spoke up, I know that I just wanted to let her know about California Hope. They are great with counseling, and they'll meet you, or they'll come to you, or whatever. They are amazing people.
Fantastic.
Yeah, as far as counseling goes.
Great. Thank you very much.
No worries. And then so I got a question. I just joined in. Is there any way you could just summarize real quickly what I missed?
Sure. I think the big thing is that the registration rights agreement went through, which is very important because it means that the trust is going to have the same protections for its stock as the hedge funds. And then the other big thing, the main big ticket item, is that the judge has signed an order preliminarily, and really not preliminarily, it's a near final decision. It's called a memorandum of decision that approves the plan. That order should be made final next week. And once that's done, the last hurdle to getting everybody paid will be the funding. So we've gotten through the bankruptcy, PG&E has emerged, but it's not final until they make that last payment on August 29th. So that's kind of the big ticket items. Did you have any questions about anything specific?
Well, yeah. So okay. So the property list, I haven't even got that done. Little overwhelmed on that one, but do I need to get it done like sooner than later?
Well, here's how it works. The sooner you get it done, the sooner we can submit your case and the sooner that you'll be compensated. But that said, I know a lot of people are going through a lot, and I know there's a million things that you have to do. So we don't want this to add stress. So, take your time. Obviously, the quicker you can get it done, the better, because then we can get you compensated. But please don't stress yourself out over it.
Okay, and so question. So I can't I'm not gonna be able to print all there's like 600 pages out.
Mm-hmm.
And so do I can just do that online, or yeah?
Yeah. Absolutely.
Okay.
No, we prefer it in electronic form. So if you can do it that way, that'd be great.
Okay, excellent. Thank you so very much.
Sure. No problem. All right, who's next?
I have a question real quick.
Sure.
So with the personal property lists, how detailed are you expecting that the items, like the brands, the replacement costs, like is it expected for, or is there a formula that you guys use for replacement costs of the items we're writing down?
Well, it's really up to you. The more detailed you can make it, obviously the better. But that said, a lot of us understandably don't know the make and model of a lot of the things that we own. So basically, just do your best. And if you know something, please put it down. If you don't, then just do your best.
Okay. Thank you. And is that the same with the replacement cost? Because at one point, one of the associates said that you guys have a formula and don't worry about that piece of the puzzle. We do them.
Right.
True?
Right. One of the things we were trying to do is to work out a formula that would take the value of the home and come up with a number that could then be used for personal property. And we worked on that for quite a bit with the trustee. It doesn't look like there's going to be something that is going to be accepted. So I think we are going to have to do lists. So to the extent you can do one, again, we know it is a huge inconvenience. Please just do the best you can. And if you need help, we're happy to help you.
Okay, thank you.
Sure. All right, Chewy, who's next?
No more live chats here, Jerry.
Okay. Do we have anybody who has any more questions?
No, Jerry, I do want to.
We're good.
It was brought up. Those of you who have large amounts of files, electronic files, and you want to get them to us, send us an email requesting a link. We can provide you a link where you can upload all of your digital files. I know many times there's a size limit to each. So please let us know. We'll provide that for you and make sure we get everything you have.
Yeah, that's a good point. We can do share file, Dropbox, and that works out very well.
Oh, okay. I have Dropbox, Jerry, but I just bought some of those little what do you call those little things, to flash drives to transfer the information.
Yeah.
So can I just send it over on a link then, or just Dropbox it and get your address, or?
Yeah, whatever's easiest. So Dropbox, we have ShareFile or thumb drives. Again, the easiest for us is if it's in electronic form, because that's the way they're going to want us to submit it. But really, whatever works for all of you, that's the best.
Okay, cool. All right,
Okay.
thank you so much. Have a good night.
All right, no problem. You too. Does
care.
anybody else have any questions? All right, so let's do this again next Thursday. Hopefully, we can report then that PG&E is out of bankruptcy, and we'll just be focused on the claims resolution procedures. But if you have any questions in the interim, please let us know. And thank you again, everyone. Take care.
Thank you.